The Kansas Court of Appeals, will give you a little background. There are 14 of us. We sit in panels of 3, which doesn't seem to work out when you divide 14, but we have senior judges that help us out from time to time. We are we sit, as I say, we sit in panels of 3, and we travel around the state to hear cases. We hear cases from all points on the compass in traveling the state to bring the judicial system to the people. We come here once a year and always look forward to sitting here and having an audience of the students from the university, from Johnson County Community College, because we're treated so well, and it's a fine place to be. Plus, it's a wonderful institution. We're here today to hear a number of arguments in a number of cases. We have 4 on the docket for this morning. We had 3 for this afternoon, but one of them settled yesterday, so we're down to 6 cases overall. That does not represent the total workload of this docket, because we only, that's sort of the tip of the iceberg. We only hear oral arguments in a minor percentage of the cases that are assigned to us. The other cases will be decided by us on the briefs that have been submitted to us. The ones today, we will have the benefit of oral argument in addition to the briefs that the lawyers have prepared and submitted to us. We are I think we're a hardworking court. We get our opinions out within a matter of 60 days, and quite frankly, most of them come out quicker than that. Because of the high volume of cases that we handle, the Court of Appeals tends to be the last stop in the appellate process for most cases. Some cases go on to the Supreme Court, but for the majority of cases, this is pretty much the end of the road. We have the benefit of some able lawyers to argue their cases today, so I think you'll be in for some interesting arguments on some little different and some rather complex cases. For the benefit of counsel, as you know, we have read your briefs. We have a pretty good handle on the facts and what your theories are. You are allotted 15 minutes aside, except for our first case, which gets 20 minutes aside. I'll keep track of time for you, but because your time is limited, please feel free to jump right into the merits of your case. Although I'll be a little bit liberal with the time, because quite frankly, for the benefit of our students, it might be good for them to have some concept of what the heck we're all talking about. Sometimes helps us too to know what the heck you're talking about. When I announce the case, if you will state your appearances, and let me know if you're the appellant or whether you want rebuttal time. I will try to keep track of that for you, and we'll proceed directly to the docket. Our first case is number 113692 in the matter of the equalization appeal of Arc Suite Life Rose Hill LLC for the year 2013 in Johnson County.
Good morning.
Parties state their appearances, please.
Catherine Myers on behalf of Johnson County, Kansas.
Darcy Dimitri Hill on behalf of ARC Sweet Life Rose Hill, LLC.
Well, thank you very much. Ms. Myers, do you desire some rebuttal time?
3 minutes, please.
3 minutes. All right, you've got it.
This is an appeal from a tax appeal before the Board of Tax Appeals involving a senior living facility consisting of assisted living and skilled nursing care. The taxpayer presented an expert, a Mr. Bohm, who valued the senior living facility based on a going concern valuation. That is also sometimes referred to as a business enterprise valuation. Under Kansas law, for ad valorem tax purposes, real property is to be valued based on generally accepted appraisal practice and principles. That's in KSA 79503A.
Just so I think we all understand, this was when the property was being appraised for tax purposes by the county
Yes,
and for assessing property taxes, and schools would use that for assessing their taxes also.
it is used for any taxing jurisdiction to determine their mill levies, yes.
And there was a dispute over the value of the property, and it ultimately went to the Board of Tax Appeals. They decided it, and that's what brought it here?
Yes,
Okay.
yes.
Thank you.
What is our scope of review?
Your scope of review in this matter is based on the Act for Judicial Review. Your scope of review is based on the record, and you are to make your determination if it's a fact question based on whether or not the fact is supported in the record, based on the record as a whole. So you therefore consider all evidence that supports it and/or subtracts from the fact and make a determination as to whether or not the board, when it made that determination, if there was substantial evidence in the record to support it. If it's a question of law, there is no longer any deference given to the agency below, and you are free to make your own determinations without any regard to what the agency below determined for that purpose.
Now, in a case like this, there's one evaluation which says it's in the neighborhood of $9 million, and the other is in the area of 11 million.
Yes,
Now, we're not just supposed to say, 11 plus 9 equals 20 divided by 2 is 10. You are not asking for that, are you?
no, I am not. I am asking this court to overturn the Board of Tax Appeals' acceptance of the taxpayer's value, which was $9.5 million, and to reinstate the county's value, which was 11.1 or 2 million, something in that neighborhood.
Now, you have the burden of proof on this, don't you?
Yes.
Well, could you explain what you're going to have to do in order to prevail in
Yes.
this?
I have 3 issues raised here. One is that the Board of Tax Appeals determined a fact, made or implied, that is not supported in the record. That fact is, there are actually 2. They made a determination that there is goodwill involved in nursing home, senior living I don't want to call them nursing homes, senior living properties, because senior living properties are a spectrum from totally independent living and could be up through skilled nursing care.
And why wouldn't there be goodwill in the business product of that residence?
There could be, there could not be. The question is, does the market say there is? Because that is your basis. You have to go to your market to determine whether or not buyers and sellers say that there's goodwill and that they
If
put a
this
value
care-
on it.
If this care home has a positive relationship in the community for providing good services, and that's a reputation that it has built by its business plan versus one who has a reputation for providing poor services. So what is wrong with using some level of goodwill in this calculation?
There's nothing wrong in the concept of goodwill. There's nothing wrong with determining that there may be some goodwill there. The problem is, one, can you put a quantity on it? Can you quantify it? No. And 2, merely because it exists, it is an intangible. And the assumption the board makes is, 1, yes, there is goodwill, and 2, it was quantifiable, and therefore it's an intangible that should be deducted. But that is not Kansas law. First of all, for it to be an intangible that you must exclude, it has to be legally definable. And you have to be able to trade it, and you should be able to determine from the market what it is worth. For instance, a patent. That's an intangible, and it's legally definable, and it can be traded between parties exclusive of anything else. Same way with a
But don't we have a
copyright.
problem doing that here? Because you generally don't have a lot of these institutions within a, a limited geographical area. And it's very difficult to find another business or ongoing ongoing service provider. It's hard to show how much that is worth compared to another one because there just aren't that many.
Well, you can't do it. One, there are very few sales. This is true. But also, in those sales, the buyers and sellers do not proportion out the purchase price between anything other than personal property and real property.
Are you sure about that?
Yes. and-
Because there's a real difference in the tax code as to whether you classify something as goodwill or real estate or personal property, and the ability of the buyer to depreciate it and the ability of the seller to recognize it as capital gain or some other type of gain.
That is for income tax purposes, and yes, you can.
And that's spelled out in the contract between buyer and seller generally.
There is no contracts in this record anywhere.
Well, there's no sale in this record. We're just determining value.
Right. There is no data in this record, period, presented by the taxpayer to establish any value for goodwill for any purpose, for income tax purposes or for selling. The taxpayer's representative or expert acknowledged that buyers and sellers, when they sell these properties, the seller isn't selling his business too, which is what you have when you are going to capitalize goodwill for income tax purposes. There's no buying of assets. There's no buying of liabilities. There's nothing like that. They buy the building and they buy the personal property. That's all they buy. They don't purchase the name of the prior seller. They're not purchasing the license because the license to run these properties is not tradable. You can't transfer it in the state of Kansas. So all they buy are the building and the personal property. And when they fill out the sales validation questionnaire that's required in this state when you buy property, the only thing they identify is the value attributed to the real estate and the value attributed to the personal property under their contract to purchase. And that is the way it's done nationally as well, and that is what Mr. Bone testified to. No, they do not pull out or extract any value for goodwill when they purchase these real properties.
Do you characterize goodwill as the same thing as the term business value that's been used in this case?
The concept of the going concern, which is what Mr. Bone calls it, the going concern, is essentially the same thing as what some other appraisers, especially when we talk about hotel valuations, this is a common concept there too, business enterprise value, where they are say that you must extract goodwill from the real property. And they look at, and it's discussed, Mr. Bone talked about it, he includes in his goodwill the return in and of the cost for the personal property and also for startup business costs, which would be things like hiring your workforce and that type of thing before you open up your business. He considers that the business value, which some people call it goodwill. So it's business value, goodwill. They're somewhat interchangeably used by appraisers.
Well, it includes more than simply goodwill, doesn't it?
Yes, it does, in Mr.
Startup
Bone's case.
costs, obviously.
Startup cost, yes. It's more than just the goodwill. They're saying it's all of the business value that a business has in opening up a senior care facility.
And you're saying that goodwill is not used in the senior care facility industry, or in business practice as a whole?
They do not identify when they buy and sell these properties, business value or goodwill or any type of intangible at all. All they identify in, I bought a building and I bought some personal property, the total purchase
That's
price.
what's disclosed to you in the real estate questionnaire validation form.
Mr. Bohm admitted that's what they do. In his testimony, said, no, the buyers and sellers do not identify business value. And my response is, then how can you do it?
Well, didn't your rebuttal expert, Bernie Shaner, didn't he testify that Mr. Bohm used the appropriate method of arriving at a calculation?
No.
He did not?
No. What he said is that Mr. Bohm used a method that is discussed in appraisal literature, which is, and there's only one article in the record on it, and that's from the Appraisal Journal, which is published by the Appraisal Institute, but stated that it's controversial, that there's no agreement on its use, and stated that the Appraisal Journal is not an authoritative source. It is a place for appraisers to put forth ideas. And the taxpayer never qualified the Appraisal Journal as an authoritative text either. The only authoritative text is the Appraisal Institute's textbook, which is the Appraisal of Real Estate. There is now, at this time, the 14th edition. In the 14th edition, there is a chapter that is dedicated to valuing a business. And in the valuation that is in the appraisal text, they use what is called a parsing method. And in that approach, you must extract from the business income how much of it goes to the real property, how much of that income is attributable to personal property, and how much income would be attributable to business value. That is the method that would be used in your instance if you want to depreciate business value for income tax purposes. That would be the method that you would have to use for the IRS, is to parse out the income among the three components of your business.
Well, traditionally, there are several ways of, well, you use several ways of reaching a value of the property. You can use a market data approach, comparable sales. You can use the original, how much it would cost to reproduce the property, less depreciation. You could capitalize the earnings from the business to determine what it would be valued at. Your approach is to use only the cost to reproduce the property. Is that right?
The cost to replace, but different, but
Well,
essentially the same thing, yes.
Same thing. You
Yes.
reproduce it.
Yes, you,
Let's build this from scratch and then depreciate it down based on how many years old this facility is.
yes.
And Mr. Boehm, the taxpayer's expert, rejected that theory and applied the capitalization approach and the market approach.
Well, he did a sales comparison approach, but rejected it as unreliable.
Unreliable, that's right.
Yes, and the
All right.
reason he gave for that is because these nursing homes have so many different components to them. They can be all independent living, they can be all skilled nursing, they can be any combination of the continuum. They don't, when they set their rates, they don't set those rates based on, okay, this is how much the rate goes to your renting your unit. This is how much goes to the services that we are going to provide to you. They don't break any of that out. And Mr. Boehm rejected the sales comparison approach for that reason, that it is so difficult to actually do a comparison between properties because they're so vastly different within the market. The response to that is, well, you have that same problem with the income approach. And he doesn't make any attempt to separate out just the real estate value in his income approach until the very end. He uses the income from the property from all sources, whether it was from real estate, services, miscellaneous type income. He uses all of that income stream based on the subject's actual income, not on market. He says it's market, but he never went through the process of taking his lease comparables and doing any adjustments to them, like you would in a sales comparison approach, to determine what is an actual market rate. He didn't do that. And he also uses all of the expenses that go into it as well. So his net operating income is a net operating income from all sources at the property.
Wouldn't an investor who's buying a up and running senior living facility in determining how much it's worth based on the capitalizing of income approach, take all those things into account in deciding what the value of the property is?
Yes, they would, and I'm sure that's what they do, but they do not, when they come to a decision on how much that property is worth, they're not attributing any of it to these business value things. They don't parse out, well, if I had to do this myself and start it up, if I had to start this all up from new, would be my marketing costs, these would be my X, Y, and Z. They don't do that. But Mr. Bohm
I don't
is.
understand why you say they don't do that.
They don't. There's no evidence even that they do.
I've never been involved in the selling of a business that there wasn't some calculation for goodwill between the buyer and the seller. So
They're not buying a business. They're not buying a business. They're not buying a name. They're not buying a license.
you
They're not.
You don't know that the buyer for Rose Hill wouldn't come in and say, this name's got a good reputation in the community, so I'm gonna buy it and leave the name the same and have it owned by such and such LLC.
Why would Rose Hill sell its name when it owns it? And it doesn't. I mean, they don't do that. It might seem logical to you that they do, but they do not. The names do not go with the property. The management doesn't, they're not buying assets, they're not buying liabilities, they're not buying copyrights, they're not buying
Now, Are
trademarks.
you tying this strictly to long-term care facilities, or are you tying this to businesses in general?
To the purchase of we are talking about valuing an individual senior care facility. These properties are bought and sold amongst companies, but they only buy that piece of property. They don't buy the company that owns it. They're just trading real estate back and forth among themselves. They're not buying a business. And there's no, even if they were, Mr. Bohm doesn't quantify it in any way. What he does is he takes his going concern value, which he did off of a discounted cash flow analysis, arrives at what the property is worth at the terminal end, which was, I think, 13 something. And then he says, to determine the amount of business value in this property, I'm going to subtract from it what this property value would be if it were entirely vacant, which he says is $10 million. Therefore, he says that the business value is $3.5 million. That is not an accepted appraisal practice, and it's not the way you value real property in Kansas. We don't,
You're bumping into your rebuttal time.
sorry.
So, no, it's yours to use.
But why is
I'll
that-
give you a little extra time.
Why
because-
is that not an accepted valuation process in Kansas?
In Kansas, you value the property as you find it. The property is fully occupied and has been for years.
No, the record doesn't say it's fully occupied. It's got a percentage of vacancy.
It's 88% occupied. It's not vacant.
Well, I know that, but that's not 100%.
Well, he said it was at stabilized vacancy. Stabilized.
Okay.
Okay? that means it's not vacant. He wants to value it as if it's 100% empty, and it is not.
But isn't that a cross valuation that he looked at to determine his total picture?
What is the basis for determining, though, that if you say it's worth 10 million, which he doesn't support, by the way, he makes an assumption that if it were vacant on January 1, it would take 2 years to lease it up. But he doesn't provide any support for that. That he's making the assumption that any value that's there after it's been operating all these years, with leases in place for occupants who are leasing real property as well as these other things that they get as well, that all of that is just business value. That's like saying if you have a 90% occupied office building, which will work on full-service leases, that all of that is business value. The occupancy is business value. He's treating it as if the occupancy is an intangible. It's not. That's a property right. The right to occupy is a property right. We value property rights. The occupancy has value.
You're
He-
pushing it, counsel. I mean,
Okay.
I'm at the point where I'm not going to save you 3 minutes if you keep going.
Okay.
All right. Counsel.
Good morning. May it please the court. Before, I would like to clear something up that you just discussed. Ms. Myers, the county indicated that these businesses don't sell, that they just buy real estate. And that is not true. When these sell, and they do sell, given it's not as prevalent as a home or something like that that sells every day, they do sell. Do you think they make all the residents move out and then lease them up again once the sale is complete? No, you're buying the real estate, you're buying the residents that are there, you're buying, we'll call it goodwill, the local relationships that this property, you know, they rely heavily on doctor referrals and hospital referrals for sick people. So that's going to transfer. The specialized workforce, they don't fire everybody. And so when she says they don't sell as a business, that it's just real estate, that's just not true. And in
But
fact,
how can you evaluate that? This goodwill, which, let's say, I think obviously does exist. How do you evaluate that?
well, I think it's challenging, and I think that's the crux of the case here. We talk about, not just in this property type, in general, the business enterprise valuation. There's lots of literature on how to extract business value. Ms. Myers referenced the appraisal of real estate book. They have some sections on how to do it. The USPAP requirements say that if an appraisal assignment requires that you deduct personal property or business value, the appraiser has to be competent in doing that. But in both MAI appraisers at the hearing testified that while there's consensus that there's business value that needs to be deducted across all property types, not every, but not just senior living, there isn't consensus on exactly how to do it. And that is what was said.
Is this, it's as much an art as a science? Do we, and did the board put a lot of trust in the professional opinion of
Well,
one expert or
absolutely.
another?
Absolutely, and that's one of the things that I wanted to point out. I want to go back just briefly, if I can, to the standard of review that is today, especially for this issue when you're looking at the substantial and competent evidence. One thing, this court must consider the credibility determinations made by BOTA. All of the witnesses at the hearing were expert witnesses offering their opinion of value. We had a county appraiser employee who offered his opinion on a mass appraisal, And then there were two MAIs, the taxpayer MAI and the county's rebuttal MAI. And so especially in this case type, you're heavily relying on BOTA to determine the credibility, the expertise of the witnesses before them.
So what's the difference between a mass appraisal by the county and the MIA type of appraisal by your expert and the county's other expert?
Well, the county, for a mass appraisal, they do studies based on property type for the whole county. So they'll, maybe let's take a step back from this property type, but if we're talking about, we talked about office buildings. So they'll survey the market and see what recent market leases were for office buildings, and they'll determine a rental range. And they'll do the same thing for expenses and
And that would depend on
and
location
vacancy.
too, right?
It depends on location, and it's very study heavy. You have a lot of studies, and then you determine parameters, and then you try and fit those parameters to your property type. For a fee appraisal that the MAIs did, it's completely property specific. Now, while they will look at market data, it's market data for that property. And they actually develop an appraisal just for the property. So the county only did a cost approach in their mass appraisal because they said they lacked sales data, they lacked market data to do a sales comparison approach, which the county never does a sales comparison approach because there's not an approved PVD approach to do sales. But they do on other property types do an income approach. They said they lacked market data to do an income approach. And most importantly, the county's witness said for this property type, and I quote, contained lots of business value, they didn't have the mechanisms to deduct business value. The county, that was Perry Bailey, the one who works in the county appraiser's office, testified, this property type has a lot of business value. And so that's why they relied exclusively on the cost approach. Ultimately, BOTA found that the county's cost approach, which was its sole methodology because they only presented the mass appraisal in its case in chief, said,
Just so I'm clear on this, you're saying business value is the same thing as goodwill?
no, goodwill's just part of business value. You know, and in fact, if you read my brief,
Encompass it.
I didn't say goodwill at all. I say a business value because it encompasses a lot more than business value.
Now,
Or goodwill,
your
I'm sorry.
your expert relied strictly on the income approach, capitalizing income. Is that correct?
Well, he
You said it's
ultimately,
the only reliable indicator of value.
right, he did all three approaches.
Well, I understand.
Okay, but ultimately, yes, he relied on the income approach.
Mr. Shaner, who's the county's MAI appraisal expert, he said there was no business value in the property because of external obsolescence. And I take it from that, he was saying that the facility didn't produce enough income to generate any net profits over and above depreciation of the property.
Right.
And if that's true, well, first off, you would concede then that or maybe not, we'll find out here. If Mr. Shaner is correct, there's no income to capitalize, is there? No net income after offsetting depreciation for the building.
Well, we disagree with that. Certainly, this property
Well,
is a successful property.
So
It
are you
has-
are you saying that the income does, Mr. Shaner is incorrect when he says that the
I think-
income is substantially more than what it takes to offset depreciation?
Well, we didn't delve in a lot to Mr. Shaner's appraisal at the hearing because he was rebuttal. But let me just say that he tied his income approach back to his cost approach. I think his cost approach had some significant flaws. I don't think he accounted for depreciation and external obsolescence correctly. And so then when he did his income approach, he looked at his cost approach and said, oh, there's not any business value here. So I think it's simplistic to say that there wasn't business value because we had some other issues with his appraisal, but he testified very briefly. It was just in rebuttal, and ultimately we didn't get into too much of his opinion of value.
So in calculating business value, you're, well, on a cost approach, you're looking at something more than just the capitalizing the net income from the property?
On a cost approach?
Yeah. No, I'm sorry, on an income approach, capitalizing income. You're,
Yeah. Yes, you're capitalizing the income that the entire business generates. Everybody's familiar with this property type. You go in and you're gonna pay $3,000 to $5,000 a month, and you're getting more than a room. You're getting specialized care, you're getting, especially this facility, we all toured it. There was, specialized nursing care, meals, social activities. I mean, it's almost like a fraternity or sorority for the elderly. They're actually really nice facilities, and they're providing a lot more than just,
so what does your expert say is the capitalization rate that should be applied in capitalizing income?
the capitalization rate.
Do you recall offhand?
I don't have that in front
Okay,
of me,
all
I'm
right,
sorry.
all right. We'll dig around. Thank you.
Thank you.
Council, obviously, the board was blown away by Mr. Boehm's testimony.
Right, yeah, and that's,
What burden and what specific things does your opposition have to do to get us to see it otherwise?
well, if we're looking at whether there is substantial and competent evidence, I think she has to show that when you're going back and looking at all of the evidence in light of the record as the whole, that there's not substantial evidence to support BOTA's findings. And in this case, I think that's very hard to do, especially since the county only relied on a cost approach. All of the witnesses said the cost approach wasn't the most effective or the best implication of fair market value. Even the county's Perry Bailey witness, that is the county appraiser employee, he even testified that, let's see if I can find it. Basically, I don't have his words, but he said that an income approach would be more reliable because buyers and sellers wouldn't look at a mass appraisal cost approach. He knows that, and he acknowledges that, but he didn't have the tools to do an income approach because he couldn't deduct business value. Then you have the taxpayer's appraiser, Mr. Boehm, who rejected the cost approach for a variety of reasons, but ultimately it came down to, we're supposed to be valuing fair market value. And fair market value is a willing buyer and a willing seller and what they would, be reasonable in accepting and paying. And in that situation, and in that case, they're not looking at a cost approach. They may if the property was a year old, but not a 10-year-old property.
Just for the benefit of the audience here, the county has valued this at 11.2 million, basically.
Mhm.
And the BOTA has determined a value of 9.2 million, give or take 2.5 million.
9.25, I believe.
All right, so let's put it into real dollars for the folks that are here. Do you have any idea what the county real estate taxes are for the property based upon either one of those numbers?
Do you want me to calculate it really quick? I mean, I could.
I didn't know, and maybe you know.
I don't know what the mill levy is. Let's assume the mill levy is 1 mil or 100 mils. It would be approximately, let's see, 200,000, so $20,000.
Yeah. And I think the mill levy might be close to 150.
No, it's not that.
Is it?
No, that is one.
Okay, so at 9 million or at 11 million?
The difference.
That was the difference.
difference.
That's the tax dollars at
Okay,
issue.
so the argument is about $20,000.
Right. And one thing for the audience perspective, or
For the students.
for the benefit for the students, property in Kansas has different assessment rates. So commercial property is assessed at 25%, which you would think a senior living facility would be commercial, but in fact, this is still assessed at residential, and so it has the 11.5% assessment rate. Houses pay less on taxes and value, they're just assessed at a
And an
different level.
office property pays 25%.
Right, and office property, retail, warehouse, all of those would pay 25%.
Thank you. It's not relevant to our issue, but I thought it might be beneficial to the audience.
Yeah, no, it is, and sorry I didn't know those numbers. I look at valuation, not the tax dollars. A couple other things. I mean, I think we've talked about this, but I do just want to talk again. One, this property has sold, and it was called Sweet Life Rose Hill before it sold. And so the argument that the name doesn't transfer and all of this doesn't transfer, it does. It does transfer. And the witnesses did testify that it's hard to find an allocation, you know, when someone's buying a business for real estate, personal property, and then this business value. That's not to say that they don't have an internal allocation. That's to say that on the COV that you're required to fill out when you sell property, the only question is, was a business sold as part of this? And you check a box. It doesn't ask for how you allocate it, it just asks for the allocation of personal property. And so I think that argument has been really inflated when we say, well, they don't allocate anything to business. They do, it's just not on that form. And it's not, a lot of those are internal, not necessarily for this property type, but we've had clients that sell other big retail properties or something, and those internal calculations to how they've allocated, they don't want those out. Those are highly protective. So that's not something that's going to be floating around the market, but certainly not, it's not fair to say that they don't allocate anything to business, because clearly they do.
Is it important that whether the name transfers or not?
Well, I guess it depends on the property that you're buying. If you're buying a property that maybe doesn't have as much reputation, you may not, and you may change it. This is actually a Brookdale location. Usually Brookdale splashes their name all over everything. They have several properties here in Johnson County, but you have to dig to see that this is Brookdale. They've kept the name. They obviously thought there was value with the name.
So the old name is still on it?
Mm-hmm.
If I understand the county's argument, or one of their arguments, is that it was improper for your expert to fail to tease out the various aspects of income that are attributed to services and other aspects of the business as opposed to the real estate itself.
Right, and I think.
What is your
And I think
argument?
she talked about this, she called it the parsing method, which is a method described in the textbook that she talked about. One quick thing about the textbook is you can't put every accepted appraisal methodology in a textbook. That's why they send out quarterly publications. It's called the Appraisal Journal. And it gives you other methodologies, other things to think about. And this exact methodology was talked about in the Appraisal Journal, which is the article, the publication from this textbook that she talked about. Excuse me. The thing about the parsing method, and I'm hoping that this is exactly the parsing method, but our appraiser said it was really too difficult to allocate that out between all of the different services. That really applies easier to properties that don't provide as many services. I mean, here we have, and this bed mix for this property type is different. They go all the way up to skilled nursing, and they have an Alzheimer's unit, and so on that side, you're paying a lot for the healthcare part, but if you're in more of independent assisted living, you're paying more for meals and the social aspect, and it's virtually impossible then to say, the $5,000 that you pay a month, we've allocated it this way. It's just really difficult and not done for this property type.
Well, what I'm trying to understand is if it can be done, is that the way it should be done in valuing the property?
Well, we hired who we think is the best appraiser
Well,
to
let's
do it.
forget it. Let's set that aside. This isn't a assisted living facility or senior living facility. This is some other business that has income from services. If in that appraisal process, would you expect to be able to parse out or tease out the income from services as opposed to the real estate itself? Is that the proper method to do it?
It could be if the services were more simplistic. Yeah, absolutely. You'd have to look at the value of all of those services and
This is in
try and
approaching a
allocate.
cost, and a capitalizing income approach to value? Is that the way, is it in that context that you do that?
Kind of in that context, you would take, you know, the total rent, and then you would allocate some towards the real estate portion, and then you'd allocate some towards services, and you can even allocate some towards, you know, the rental of personal property, and then capitalize those income streams and ultimately get a value.
Would a buyer make that distinction
No.
in capitalizing income?
Well, maybe in some property types, but certainly not this one. No. This one, the business and the real estate are so intertwined. Everybody testified that it's really hard to extract business value, and nobody advocated doing it that way.
You've just got a couple minutes to wrap up, Council.
Okay? One of the things we talked about is valuing the property as if vacant, and the county's brief talked a little bit about, and I don't want to confuse the students because it really doesn't apply to this case, but I want you to know that it doesn't apply to the case either. They don't want to value the property as if vacant, and they've talked about a dark store theory. And
Your Yellow Freight case?
Yeah.
Or not your, there you.
right, it was in that same, that context, yes. And Yellow Freight was a little different. That wasn't even advocating a dark store theory. And so I think the issue just got really, really muddled here. I mean, I could explain what the dark store theory is quickly. Is Kansas, we value property in fee simple, and so that's the whole bundle of rights. So when you sell something, you're getting everything. You have the right to occupy it, you have the right to lease it out, you have the right to tear it down, you have the right to do whatever you want with it. If you buy a property that already has a lease in place, you therefore didn't buy all of the rights, because now you can't occupy it till the lease is empty. And so the theory, very simplistically, is just you should look at sales of properties without a lease in place, because those are what sell in fee simple. That's kind of the dark store theory. It mainly is applied to retail and big box retail. That doesn't apply to this case at all. That's not what our appraiser was doing. He wasn't trying to say, well, to do it in fee simple, we really have to say that it was dark.
Empty.
And-
Dark is synonymous with empty. I take it.
Yes.
All right.
And the county also cited the Yellow Freight case, which the Yellow Freight case was very different. It was an owner-occupied office building. The main issues in that case, they were arguing about the highest and best use and whether that would ultimately convert to multi-tenant or stay as owner-occupied. And again, that case just isn't on point because it's an office, they're just very different. And in the county's brief, and I think she said it just now, that an office building, a full-service office building comes with leases and it comes with responsibilities of maintenance and janitorial and I can't remember all the things that she listed. That's not what we have here. You could easily buy an office building. It doesn't take much specialized management. I mean, it takes some, I'm not discounting that. But in our case, in this property type, it's clearly a very specialized industry, a very specialized business. And in fact, if you just take a step back, in the Yellow Freight case, the county did an income approach. They were arguing over an income approach. And in our case, the county said, that's a special use property. There's too much business value. We don't have the tools to deduct it, so we're not doing an income approach. So clearly the county treats these as different. So to say that it's the same just isn't logical.
Got about a minute, Council.
Okay? One thing that I would like to kind of point out is, in the county's brief, there were a few instances where it was alleged that there were mistakes in the taxpayer's appraisal. And I want to point out that none of those mistakes were, one, brought up at the hearing. So Mr. Bohm didn't have a chance to answer a question or explain some of the things that she was saying. I think one of them was double dipping vacancy and deducting depreciation from land, which is a non-depreciable asset. So I think it's improper. One, it seems like the county's trying to add to the record, because there isn't anything in the record to say that these were mistakes.
That's the problem of no longer requiring motions for reconsideration,
Exactly. That's exactly.
where we could identify these things.
But I want to take a step further, and I'm not trying to add anything to the record, but Mr. Bohm didn't have an opportunity to explain himself. And in fact, the county said, oh, this just shows that he doesn't have a grasp of appraisal principles. The things that were alleged absolutely weren't true in the brief. And so I to be honest, at this point, I just ask that you disregard all of those, because you're hearing from attorneys on how we're reading appraisals instead of it actually being in the record of, did you make a mistake on your cost approach? And then hearing from the expert himself to say, no, I didn't. I think you're misunderstanding.
But aren't we bound by the record and not by your arguments?
Exactly. That's why I just wanted to point that out and ask that you just disregard those. Anything else?
Any other questions?
Thank
Thank
you.
you very much. Thank you for your argument. Counsel, you have your 3 whole minutes.
Judge Purin, they have to prove that Mr. Bohm's appraisal that his method is an accepted appraisal practice. It is not. You will notice in the taxpayer's brief, they provided absolutely zero where any jurisdiction has accepted this as an accepted appraisal practice. I provided numerous cases, one in which Mr. Bohm was the expert, and it was determined that he was not credible, and this is not an accepted appraisal practice. 2, the appraisal journal is not authoritative. She didn't qualify it as authoritative by her expert. It was explicitly stated by Mr. Shaner, it is not authoritative. It is a controversial approach. It is not accepted generally in the appraisal practice. The Appraisal Institute's text is authoritative. It was done so in the record. It's been held by this court. It's authoritative. That text does not accept this appraisal practice. It doesn't show how it's done. It shows the parsing method. Judge Schroeder, you seem to have a grasp on doing business valuations in order to extract business value. That's how you do it, by the parsing method. If it is so extremely difficult to do it for a nursing home, then you would never be able to do it for any purpose. You can do it if you do it correctly. Mr. Bohm did not do it correctly.
Now-
Is there
Go ahead, proceed.
Is there any market data in the report to support his conclusion? He concludes business value is $3.5 million.
Counsel, would you use the mic just so?
He concludes it's $3.5 million. He ends up with a value for the property at around, 9.25, I think it is. 9.25 is less than the cost approach depreciated by all 3 parties. Mr. Bohm's cost approach, Mr. Shaner's cost approach, the county's cost approach. It is less than what he said the property was worth as vacant, which he said was $10 million. He comes up with 9.2. He's asserting that there is so much business value there that essentially the real estate cannot pay for itself. That is not sensible. It is not logical. Mr. Shaner was correct. If you don't have enough value in the real property and the personal property to cover the depreciated costs, which 9.25 does not do, how can you possibly have business value?
Well, counsel, couldn't it be possible, as I guess the board found, that they said, well, maybe the real estate and the personal property isn't quite up, but you mix into that the other factors.
That's my last point. Intangibles. Intangibles can be included in the value of your real property, and you don't have to exclude them. Location is an intangible factor that affects valuation.
Location, location, location. I think
Zoning
that's what we
is
did.
an intangible factor that affects valuation. Business value is an intangible. You can't extract it and sell it
But
separately.
that doesn't mean it doesn't exist.
Doesn't mean it doesn't exist, but it also means you don't need to exclude it if it does. It is just another intangible that affects the value of property incrementally, like location, like zoning. So even if it does exist, it's not excludable because it can't be separated from the real property, as has been admitted here today. It is a concept designed for property tax relief. That's all it is. It's a way to get the value down. It's not market proven, it's not generally accepted appraisal practice.
That's your time,
I
counsel.
I have one question. You cited us to the decision from the Supreme Court of Connecticut that found that Bowen's method was not credible. But didn't the court really find that his calculation and formula wasn't credible? Not that the use of the going concern approach as a method to value their property was improper? They didn't like his numbers? He had errors in his numbers, not errors in his methodology?
He has errors in this one as well. He did the exact same thing here as he did there.
Yeah, but those errors weren't brought out to Boda.
But they are in the record, and you can see them for yourself. They are there. He double dipped. Regardless of what Ms. Hill says, if you use the actual income and expenses, your vacancy is already built into it. Therefore, you can't subtract vacancy yet again. You go from a 12% vacancy to a 24% vacancy. He did double dip on his vacancy. He did depreciate land. Land is not a depreciable asset. He calls a cost approach, and he's in as a fee simple valuation of the business. There is no such thing as a fee simple valuation of a business. There is a fee simple valuation of real property. The cost approach is inherently the value of the fee simple interest of real property. You don't go in and start adding in startup costs and all that other stuff that he throws into his cost approach. It's not done. It wouldn't even be necessary to do that. It's all a way.
Counsel, I think you've answered the question.
Thank you.
Thank you.
Thank you.
Thank you very much. Thank you for your argument. We'll take the matter under advisement, get an opinion out to you as soon as we can. Our next case on the docket is case number 113232, State of Kansas versus David D. Burris. Will the parties state their appearances, please?
May it please the court, Sean Minahan for the state.
And I am Michelle Davis. I'm an attorney with the Kansas Appellate Defender Office, and I'm appearing here on behalf of David Burris.
Counsel, you've got 15 minutes. Do you need any rebuttal time?
Let's do 3 minutes of rebuttal.
All right.
Sure if I'm... Well, this case comes before you. The state's evidence is that in August of 2011, in the evening hours at a car wash in Overland Park, a gentleman by the name of Kramer was cleaning his red cab truck. He said that he was approached by a man with a gun who took his wallet and the truck. And as a result, that's what led to an aggravated robbery conviction. Kramer also testified that the man told him to get into the truck several times, and he refused, and that's what led to the attempted kidnapping conviction. And as a result of those two convictions, based upon Mr. Burris's prior convictions, based upon his criminal history, he received a sentence of 265 months in prison. So he is now serving that sentence. It's about 22 years. This case was tried to a jury. The way that the state's evidence unfolded was that a gentleman by the name of Minton, who at trial Mr. Burris contended was the actual perpetrator of the crime, Minton gave information to law enforcement as a result that implicated Mr. Burris. The police put together a 6-photo lineup with Mr. Burris's photo in it and showed it to Kramer, the owner of the red truck, and Kramer identified Mr. Burris as the perpetrator. In addition, the state's evidence was that that morning, the robbery was at night in the car wash, that earlier that day, police had responded to a hotel near the car wash and had talked to, because of a physical disturbance, had recovered some blood that later was shown to be Mr. Burris's blood, and had talked to a woman at the hotel by the name of Misty Gleason, and she is a friend of Mr. Burris's. And so going to trial, that was their evidence to connect Mr. Burris to this crime. Now, we get into the trial, and the prosecutor stands up and says, oh, Misty Gleason came into our office, and she's now providing additional information that is going to implicate Mr. Burris and Tinsley. Tinsley is a gentleman who's going to testify for the defense. She's now telling a different story. And the story that Misty Gleason told at trial was that when the police were out there at the hotel, they towed away this Jeep. And so these people at the hotel, 3 or 4 people, had no transportation. So Mr. Burris leaves the hotel with Tinsley and another gentleman saying, we're going to go to work, which Misty Gleason interprets to mean we're going to go steal. And they come back later with this red cab truck. And Mr. Burris says something about, do you think there were any surveillance videos or cameras at the car wash? And so Misty Gleason, unknown to the defense, we get into the middle of the trial, and she now wants to step forward and provide this information directly implicating Mr. Burris in the crime. Before, it wasn't just tying him to the hotel.
Now, previously, though, they'd had trouble trying to find Miss
Gleason.
Glease. And previously, she'd seen still photos, but right before the trial, she saw a video from the car wash. Isn't that a big difference that came forth?
That's the difference. Apparently, the police had interviewed her and shown her some photos, and she couldn't make an identification. But then when she shows up in the district attorney's office after the trial had started, and they show her the video, now she's saying, oh, I think that's Burris. I think I can, looking at this, I think, oh, and so it's a completely different sort of testimony.
That's what I'm trying to tease out. What are the, you're claiming that it was error to allow her to testify because she came up with contradictory statements. Were the statements she made, were they simply new additional information, or did they actually contradict what she had said earlier? And if so, what's the contradiction?
Well, a little bit both, and that's not real clear from the record. What I'm basically getting is just the statements of counsel. They didn't give us the actual evidence. Defense counsel just said. The state prosecutor starts out saying she's giving us additional information. She's now going to implicate Mr. Burris and Tinsley. The defense counsel says she's given us a different story, and this is a complete surprise to us. So
But doesn't that happen all the time in jury trials, where witnesses get up and take the stand and say something totally different than what was anticipated?
I imagine it does at
Much
times,
to the
right?
chagrin of one or more lawyers.
Absolutely, absolutely.
I mean, I've seen night and day difference between testimony at a preliminary hearing and testimony at the jury trial. And
Yeah,
that's-
me too.
And that's the function of cross-examination and the opportunity to impeach.
Yeah, and I think,
Excuse me for interrupting you, but didn't the trial judge try to make some efforts to redress this new situation by giving you the opportunity, or giving the defendant the opportunity with the counsel to talk to that person?
right, and I think there were two points of prejudice here that trial counsel was worried about. One is that, the surprise to the defense, that it was basically unfair. The second was that now that she was implicating Tinsley, they were worried that Tinsley wasn't going to testify. Tinsley did testify, and he said this was Minton. This was the defense. This wasn't me, this was Minton in the video. And so Tinsley pointed the finger at Minton. The problem with that is that at some point during his testimony, Tinsley invoked the Fifth Amendment. And so while there were attempts made to work around this problem, the defense contends that it blew up in the defense face because he's invoking his Fifth Amendment in front of the jury as soon as the prosecutor starts to push him in cross-examination. And so those two
Well,
things
doesn't
kind of go
that
together.
help your client?
The fact that he invoked the Fifth Amendment.
Yeah. He says, yeah, he testified against me just before he took the Fifth Amendment because he thought it could be used to
Incriminate him. Well, the deal is, though, I think there's a couple of couple of points here. One is that the defense moved for a new trial alleging this was prosecutorial misconduct because the judge had told the prosecutor, don't ask this guy anything that's going to cause him to invoke. The judge had appointed an attorney for Tinsley. The attorney said, as long as you don't ask him about any of these vehicles, the Jeep that was towed, any of the cars, just don't go anywhere near the cars. And then the prosecutor proceeds to ask him if he left the motel with Mr. Burris. In other words, if you leave the motel, you're leaving in a vehicle, and that's where he started getting nervous and he invoked. So it's our contention, I mean, it undermines his credibility with the jury. He's saying this is not Mr. Burris on the video, it's Minton. And then as soon as he starts to get pushed about whether he was with Mr. Burris that night, he invokes. So basically, the one key defense witness doesn't end up looking real good with the jury. So those are the errors that we're contending would warrant a new trial in this case, and that the district court erred in not granting a new trial. That concludes my remarks.
All right, very well. You've got your rebuttal time and then some.
Thank you.
We have never punished a lawyer for not taking all the time allotted.
May it please the court, Sean Minahan for the state. Unless this court has questions about the other issues, I'll stick with issue one also. First of all, the standard of review on this is abuse of discretion. So this court would have to find that no other judge in the state of Kansas would have ruled in the same way. As your honors pointed out when Michelle was up here, the identification in this was late because the officers in the state were trying to find her and track her down. I think it was actually, and it'd be in the record, I think it was actually kind of a shock when she showed up that day for the subpoena. And so they presented her the actual video of the crime, and she was able to identify the defendant by his movements, how he walked.
Well, she was formerly his girlfriend.
Right.
I mean, so there's a personal relationship between the two.
Right. And I would say that there was other evidence that she testified to, even if you're like, this is new evidence or this is contradictory evidence, which you can attack on rebuttal, on cross-examination. She had other evidence tying him to she testified to other things that tied him to the scene or to the crime, being at Knight's Inn, all that stuff. The defendant raised two prejudice issues. One, that Gleese had an audio statement, that she had made an audio statement, and that they weren't able to redact it, so to use it as cross-examination. I have no idea what this audio statement says. They didn't enter it into the record. They didn't proffer it. So there's no way for this court to know exactly what was in this, whether there was exculpatory evidence, whether there was inculpatory evidence. And so...
And why weren't they able to redact it? I mean,
right, that's the other question.
that's not a hard process today with computers.
Yeah, although it may be a little bit harder for a defense attorney who doesn't have the resources that the state can send one back and have secretaries redact it while the trial's going on. But still, they didn't even ask to, can we take a couple hours or whatever? Or state, would you mind sitting, walking me through this? You come up to the state's office, we have the equipment, sit right with us. We can decide right on the spot what gets redacted and what doesn't. I mean, these things can happen all the time in trial, and they can be remedied. But there's no record in this case to establish what was on that proffer. Also, Tinsley's testimony was affected. I'm not sure they could have received a better situation with Tinsley's testimony. Not only did he testify exactly to a couple of issues they wanted to bring out in Tinsley, that he looked at the surveillance video and said that that's not the defendant, that's Minton. But when he was on cross-examination and the questions he was being asked questions by the state, he just shut down. Said, I'm not going to answer any more on the Fifth Amendment. Now, I think if you look at the questions that the prosecutor made, none of them implicated the defendant's Fifth Amendment rights. I mean, he asked, you didn't tell them all, you didn't sorry, you didn't tell them that you were with David Burris and Misty Gleason and Kelly DeVault. And this was about the Knights Inn, being at the Knights Inn. And did you tell them that when David showed up, he was saying, let's go, let's go, let's go, and that the black dude left first? Did you tell them that? Well, that's exculpatory for Tinsley. If he's at the Knights Inn, when the defendant comes back and says, let's go, that means that he wasn't with the defendant robbing the victim. And then did you tell the police that you and Mr. Burris and Kelly DeVault and Misty Gleason then left and went to the Quick Trip? Again, that was after this crime. So none of these questions that were posed to Tinsley were violated his Fifth Amendment rights.
And you believe the record supports that the victim positively identified the defendant here?
Yes, he, through his own testimony, I think he identified him in court even, and through a lineup that one of the officers gave him, so.
Thank you.
And then you have the video surveillance where the jury watched in trial and could have made a decision on their own that whether that was the defendant or not. So, unless this court has any questions. Thank you.
You have 5 minutes.
I would waive my rebuttal unless there are questions.
Questions? Thank you very much.
Thank you.
Thank you for your
Bravo,
argument.
counsel, bravo.
We'll take the matter under advisement and get an opinion out for you. Our third case this morning is number 114000. Jerome L. Bratton versus City of Atchison, Kansas. Will the parties state their appearances, please?
Plaintiff appellant appears by and through Ronald Schneider. Plaintiff appellant is also in the hearing room, sitting to my left.
And the appellee City of Atchison, Kansas appears by and through David R. Cooper and also through its city manager, Trey Cockey.
Mr. Schneider, you have 15 minutes. Do you want some rebuttal time?
Yes, Judge, I would like 10 minutes for argument, 5 minutes for rebuttal. And if you would please tell me when I have 2 minutes left in my first 10 minutes,
I'll try to do
I'd
that.
appreciate it.
I'll do my best.
Thank you, Your Honor.
Mr. Schneider, after looking through the record and reading the briefs, is your main argument that your client did not receive proper notice? Or are there other issues that you would like to address?
That is one of the main arguments, and I don't mean to be aloof with you, but we are arguing that there are two main arguments that all result in the same consequences, that the state's enabling statute was there and established by the legislature, and it prescribes specific notice requirements. The city's habitual violator ordinance, which was established to address what they considered habitual violators, violated and exceeded the enabling legislation. And as a result of all that, my client received no notice because of the habitual violator enactment and application itself.
Well, he received some notice at the beginning of his disputes with the city, didn't he? I read this, it was the later incidents after they wished to bring into effect the habitual violator provision that is causing the problem here.
Well, Judge, the habitual violator order, what they call an order, and I argue is a tremendous misnomer and misrepresentation, was issued in June 2010. We stipulate and agree that he received for the very first time notice of that determination about a year later in June 2011. Then, thereafter, there were 9 events where the city went on his property that he either owned or used as a tenant without notice of either one of those, and they just waived the habitual violator order, saying we have the authority to proceed.
So with
Now-
the habitual, I'm sorry,
Now, as I understand it, the issue here was that he allegedly kept trash, garbage, maybe old vehicles, things like that, on several pieces of property within the city. And the city apparently got tired of seeing these things and brought this habitual violator act and saying that we no longer have to give you any further notice if we want to move. Am I correct in stating the background?
Yes, that's correct, but I would like to qualify. The vehicles were not just dilapidated vehicles. One of them was an RV worth thousands of dollars. We were seeking damages based upon the value of the property of about $34,000. There were a total of 6 vehicles, many of them capable of running or running at that time. They may have had a bad battery or a flat tire. But what you said is correct, Judge.
All right, thank you.
All right, so the city made a determination he was a habitual violator
Yes,
without notice to him.
that is correct.
All right, and then he has the right to appeal that determination.
Under the statute, KSA 212, I think.
And he has right to appeal that notice within 30 days,
That's correct.
and he didn't receive notice for 1 year.
For 1 year, that's correct.
Right. So let's just, for purposes of discussion, say he received the notice timely. What's his burden on appeal to get the habitual violator determination reversed before the district court?
His burden at that time is to allege essentially what we've alleged in this case, that the habitual violator ordinance exceeds and contradicts the authority in the enabling legislation. It is unconstitutional.
But isn't it a different burden or issue than trying to raise that same issue before the city, before it makes that determination?
I think so, yes, yes. I think due process requires that he receive notice before they make the determination. In its order, they called this a hearing. That hearing composed of the administrative hearing officer, Mr. McDermott, who's also the fire chief of the city of Atchison, received a phone call from the secretary, said, "Come on over, we have a prepared order for you to sign." He stands at her desk and signs it. No evidence. He claims in his deposition that he believes he reviewed the file before he did that. And we maintain that required notice as well. Significant impact upon Mr. Bratton could result as a consequence.
None
Now,
of that matters if they did not have the authority to pass that in the first place.
correct. I mean, we argue,
Isn't that your real argument?
our real argument, all this is void.
Right.
I point out habitual violator definition is one notice within the previous 12 months. That notice could be even for having your lawn too long, but notice, not failure to complete. You could receive a notice says your grass is too long, mow it. You mow the lawn, and then you have the potential to be a habitual violator. I mean, constitutionally, we argue that it's substantive due process violation, void for vagueness, ambiguity, and all those other arguments. So under these circumstances, we argue that the habitual violator ordinance is clearly in violation of the enabling legislation. And I would like to outline the fundamental issues for notice and procedures under the enabling legislation, which is KSA 1617E. First, the city clerk shall issue a notice to the owner or agent of the property to remove or abate the things specifically described in the notice, and that he or she should have 10 days or less for each and every allegation to remove or correct that alleged nuisance. Each and every, not just once is enough. The notice shall state that the recipient may request a hearing before the expiration of the waiting time. The notice shall be served on the owner or agent by certified mail or personally, and if the owner or agent fails to abate or request a hearing in the time designated, then and only then may the city proceed to abate the alleged nuisance, and the only thing they may do is charge for the cost of abatement. Now, the habitual violator ordinance, which was adopted after the city first passed its original nuisance ordinance, and I would like to point out, in its original nuisance ordinance adoption, they refer to their authority to do so under the enabling legislation. The preamble of the ordinance says that. The habitual violations are defined or stated if the owner or legal entity in control of any of the land has previously received a notice, and I emphasize a notice, to abate a nuisance on any property owned or controlled by that person or legal entity within the city of Atchison in the preceding 12 months, then the city may, not shall or must, may determine that the owner of legal entity is a habitual violator. What are the consequences? The ordinance provides that the city may file an administrative order allowing the city to further abate violations without notice and assess the abatement costs with an administrative penalty of $300. So,
You're up to 2 minutes before your rebuttal time.
thank you very much. Not only is it substantively improper, but the ordinance itself, but we argue that each and every of the 9 violations is an additional violation. Now, I question appellee's arguments that the claim of habitual violator is not in conflict, obviously, with the enabling legislation, and they rely upon the Home Rule Charter. Well, if you look at the most applicable case of Barnes, Court of Appeals said clearly this is the enabling legislation, and it takes away any argument of home rule. Further, there's nothing in the record that shows the city adopted a Home Rule Charter ordinance. I also question how appellee can argue that the substantive due process was not raised at the trial level. As stated in my reply brief, it is. I also question and challenge that the appellee argues that the issue of whether the June 4th, 2010 administrative order was appealable, because they claim it was not raised at the trial level. It's in the pretrial order, it's in the pretrial questionnaire. And number 4, the only procedural issue it is alleged is, that we allege by the appellee to raise, is the hearing. That's not the case. I argue that it's the city here that really had a number of other alternatives to enforce its ordinance if they had someone who they thought was a chronic problem. For instance, raise the fines, double the fines, then foreclose upon the land. I think it's lazy code enforcement, sloppy, and illegal. Not only illegal, but unconstitutional. It's the most fundamental right that every citizen has, is to receive notice of hearing and given an opportunity for a reasonable and meaningful hearing at a meaningful time. Thank you.
Did the city officers who went upon your client's land have the right to rely upon the ordinance in executing and going on the land?
The defendant, of course, argues that they did. If it's void, then no. They probably relied upon it in good faith. That gets into a very question. Did they have a right then? If it's a void ordinance and a void order, therefore, I would argue no.
But then you get back to the good faith argument.
Was it executed in good faith? I think if you look at the history of this case and statements made in deposition, especially by Curtis Wheeler, the sole and only enforcement officer is the one who he stated during deposition. He helped draft, if not entirely drafted the ordinance with consultation with legal counsel, but also he had discretionary powers. And he stated that he could enforce it as he deemed fit. And, you know, under the law here, everyone who's received, and there are dozens, if not hundreds, of violations issued each year, every one of those persons have the potential to be deemed a habitual violator. So by doing this against Mr. Bratton, I think there's a very strong argument that it was not made in goodwill. I would trust that the defendant would say he relied upon an ordinance that he thought was legal.
Thank you.
Thank you.
May it please the court again, David Cooper for the city.
Counsel?
Counsel, from my standpoint, it seems that you have two big problems. Number one, did the ordinance that the city passed to have a habitual violator provision, did that go too far based on what the enabling legislation allowed you to do? And number two, shouldn't there have been some kind of a notice on those later violations where apparently there was no notice given and the city just proceeded on the basis that, well, he did it before and we don't have to give him any further notice?
Well, first, given that you're wearing the robe, from your point of view, is the one that matters.
Thank you for noticing.
But in more direct answer to your questions, and it's kind of my launch point here, is one, no, it doesn't exceed the enabling legislation. That's a different question than constitutional parameters over breadth and the like. And part two of that is that's a different lawsuit than this lawsuit. This is a lawsuit for damages claiming that Mr. Bratton was deprived of property. You took my stuff without first being afforded due process. That's what this lawsuit is, and Mr. Bratton lost that lawsuit because he was provided due process. What Mr. Bratton has tried to make this action about is that the Good Neighbor Ordinance, the nuisance abatement ordinances of the city of Atchison, and then the later on adopted habitual violator provisions of that ordinance are unconstitutionally vague. Well, one, they're not too vague. We can understand what it says. But beyond the question of the validity, this is not a lawsuit asking for declaratory relief or an injunctive relief, declaring the ordinance invalid, or enjoining the city from enforcing its ordinance. This is a lawsuit saying, you took my stuff, give it back, or pay me for it. So those are two different lawsuits. And we've seen a lot of briefing and heard a lot of arguments about the lawsuit that's not in front of the court. Okay, the fundamentals of procedural due process is a right before one is deprived of life, liberty, or property. Here we're talking about property. To be heard, to have notice and an opportunity to be heard in a meaningful time, in a meaningful manner before the property is taken. Now, Mr. Bratton in this lawsuit claims that the city was without authority to take his stuff. That's inaccurate. There is enabling legislation and ordinances and an order, all that allowed Mr. Wheeler and the city's contractor to take his stuff. It's not his stuff, it's trash.
So when did he get notice of the habitual violator designation?
By his stipulation, he got notice of the habitual violator order on June 16, 2011, and that's one of the things.
Which is a year after it was done.
True. And one of my notes during counsel's argument is, we don't stipulate and agree that that's the first time he saw the order. That's just the first time Mr. Bratton agrees that he saw the order. We were preparing to proceed to trial, and with a mountain of notices showing every time he got a nuisance abatement notice, he got a copy of that order. And he got a copy of that order in June 2010. And what was the evidence we were going to offer in support of that? This is, again, part of the record, part of the summary judgment record. Mr. Bratton owns literally dozens of properties in the city of Atchison. We're talking about 3 properties in this case. Most are vacant, but one of these has an old church, one has an old residence, and another has an old residence. And the circumstance was Mr. Bratton, by count, through the time of the habitual violator notice, had 97 nuisance violation notices, more than 200 weed violation notices. So yes, the city got tired of dealing with Mr. Bratton and upped the ante a bit.
Well, council, obviously, Mr. Bratton had been a pain in the neck to the city. But, you know, what about like in case of traffic violations? You know, can we say, well, Mr. Bratton has been caught speeding 30 times. We no longer have to tell him that a police officer saw that he was speeding. We can just find him guilty and proceed from there.
If, first off, no. Second, you move from the deprivation of property to the criminal sanction and the restrictions on liberty, which ups the amount of due process due to an individual before they're deprived of their, in this case, liberty. And the Kansas statutes addressing nuisance violation notices, specifically weed notices as well, specifically recognize the ability to, after so many, that's it, we're just going to come take care of the problem and send you a bill after the fact. So that's permitted under Kansas statutes. And to address the issue of the validity of this particular ordinance, I find it telling that the language is enabling legislation, because that's what we have. We have enabling legislation. For the audience, sorry to bore you, but Kansas recognizes that some cities are going to be of a certain size that they're not going to bother to go through the effort of adopting a specific set of ordinances tailored to the circumstances of the city. And they provide one-size-fits-all statutory authority to abate nuisances. That's KSA 12-1216 sub E, little Roman numeral E with no parentheses around it. In that same series, sub G is enabling legislation that enables any city in the state of Kansas to adopt its own set of ordinances other or different from E. The prohibition on cities is they can't allow something the statute forbids, and they can't forbid something the statute allows. We don't have that here. Also, of significant importance in this case.
But does the enabling statute say with notice?
The enabling statute sub G says the cities may adopt ordinances, I've got it.
Well, they can't allow something that's prohibited by the enabling
Right.
statute. And my question is, doesn't the enabling statute say you can pass ordinances that permit you to seize and clear this property when given notice?
It allows you to abate nuisances with notice. In the circumstance here, and we're not dealing with a facial challenge of this ordinance, we're dealing with an as applied. And we begin first with when the habitual violator order was signed, it was accompanied by I want to make sure I've got it, 4 nuisance violation notices on the same day, June 4, 2010. So when he says there were several, yes, there were several in June 2010, and preceding June 2010, Mr. Bratton had 14 pending nuisance violation notices in the 12 months preceding. In the 12 months after the order was signed, there were 7 more that went out, and in fact, the order he did get was in an envelope that accompanied the 3 April and 1 May nuisance violation notice. So again, when he says he got the order with the packet, he did. He got a packet. And history has shown the one thing Mr. Bratton did was ignore nuisance violation notices. So coming back to the significance of the enabling legislation for cities, Kansas has constitutional home rule for cities, statutory home rule for counties. The Barnes versus Cali County case cited by and relied upon by Mr. Bratton's counsel is a county statute, a county resolution. Counties, if they're not given the express authority by the state, can't do it unless they go through a charter like charter resolution for counties. Cities do charter ordinances, but cities only need to charter out of when there's a non-uniform statute, this is a uniform statute, or in the absence of enabling legislation, here we have some. And they didn't adopt conflicting. Home charter ordinances allow cities to adopt conflicting provisions, and these do not conflict. When we're addressing the constitutional claims that are at issue, first, a substantive due process claim. That's a different animal. The rights protected by substantive due process claims are those of sexual privacy, marriage, the right to marry, who you marry, the right to raise and bear children, and frankly, those rights are not enumerated, are not at issue here. Additionally, we don't go the route of substantive due process for analysis of a given claim if there is a specific constitutional amendment that covers the conduct at issue. Now that's, when I looked, I didn't see that I gave you a cite for that proposition in the brief. So that's County of Sacramento versus Lewis, 523 U.S. 533. It's a 1998 case.
533 U.S.?
Yes, 833, if I'm reading my chicken scratch correct.
Okay, that's a U.S. Supreme Court case.
Correct. And
Out of something that happened in California?
yeah, that actually involves a high-speed motorcycle chase, and there was a claim that that the motorcyclist who was chased until he crashed his motorcycle and killed his passenger, that was a claim that the passenger's substantive due process rights were violated. The holding there is, if the Fourth Amendment applies, we don't need to look at the substantive due process claim. Same thing, Fourth Amendment applies here. Now, this is not this is a seizure case, it's not an illegal search case. Was notice and an opportunity to be heard provided.
But there is a substantive right to, against the taking of your property without compensation, isn't there?
It depends on if it's property, and then,
Well,
it depends on the property and how it's taken. One of the issues here is this was trash, it was not property.
Well, that's a fact question we can't deal with.
True, and to the extent he cared about the cars, he got them out of impound, and those were explicitly held by the judge at the trial court level to be subject to a waiver and estoppel claim, and those are not at issue. Do you have a right to not have your stuff taken without due process? Here,
without
the process
compensation.
was he had notice that he had been declared a habitual violator. The order itself explicitly tells him what that means, cites to the provisions of it, and tells him, if you disagree with this, you have a right of appeal. You have a right to be heard at a meaningful time, in a meaningful manner, before we come take your stuff. And he didn't avail himself of that right to be heard at a meaningful time, in a meaningful manner.
You're saying you didn't come and take his stuff for a year.
Well, no, in this instance, I'm saying we didn't come and take his stuff for a month after he admits he got it.
Yeah, but you're saying that the first notice went out shortly after, according to your document, shortly after it was determined that he was a habitual violator.
True. But on this record, based upon the stipulation of Mr. Bratton that he did in fact get that notice, and we'll assume for the purposes of the case, because we have to, that he got this notice for the first time in June of 2011. That is still before any of the abatement actions at issue in this case. And I should note, there were 9 abatement actions. Only 4 are still hanging fire in this case because the other 5 are barred by the statute of limitations. So when we're talking about 9 abatement actions, only 4 are at issue.
You've got about 2 minutes left, Counsel.
Okay. So he did get notice, he did get an opportunity to be heard. The argument is it's too vague, but no, if you read both the ordinance, which was referred to, you read the order says, being found a habitual violator allows the city, I'm going to paraphrase, to abate further violations against said owner.
Closer to the mic.
Sorry, against said owner, yeah, I can hear myself better now, or the legal entity in control of any land without notice and assess the statement cost as an administrative penalty of $300 per incident. And then down at the bottom, it tells him of his appeal rights.
The gentleman in the back was telling me.
And again, we're dealing with an as-applied challenge here, not a facial challenge to this ordinance. This is not a criminal sanction. The ordinance and the order themselves both put Mr. Bratton on notice of what the city intended to do. He did nothing on it, or nothing to it, and the relief he's asking for is money, not a declaration that the ordinance is unconstitutional. The requirements of due process, notice, and an opportunity to be heard were met. I need to address briefly the tort claims theories that are advanced by Mr. Bratton as well, because he did raise those in his brief. He claims state law claims of trespass and conversion. I think everybody in the room knows what trespass means. Conversion is the civil version of theft. You took my stuff. And he alleged a negligence claim. Now, the trespass, just like a law enforcement officer, a battery is the unlawful use of force on another one. Law enforcement officers are privileged to use force in certain circumstances. By the same token, code enforcement officers are privileged to enter upon land and to take things that they're authorized to take by their ordinance and their orders. That's, Judge Bednar held that applied in this circumstance, and it does, and it did. Likewise, the negligence claim, the duty owed here is not a duty owed to Mr. Bratton. The duty owed is a duty to the public at large to keep the city livable. Further, the Tort Claims Act has explicit exemptions to liability, including the enforcement or failure to enforce a law, valid or invalid. And Judge Bednar held that would apply as well.
You got about 30 seconds, counsel.
Well, that all being said, this is a lawsuit about whether Mr. Bratton was given notice and had an opportunity to be heard before his stuff was taken. He got that notice. He stipulates he got that notice. He had an opportunity to be heard, and he failed to avail himself of it, and his property was taken after he got that notice and the opportunity to be heard. Absent further questions from the bench, we will stand on the remainder of our briefs.
Thank you. Mr. Schneider?
Thank you, Your Honor. Frankly, I'm miffed at counsel's argument that this is only a challenge to the constitutionality question of due process. If referring to the court's order or memorandum opinion on the motion for summary judgment, the court itself writes, the plaintiff argues that City Ordinance Number 637 goes beyond the city's power to adopt a nuisance ordinance as authorized by the state's enabling statute and is therefore void. Plaintiff argues that the enabling statute requires notice to be given to a property owner or legal entity. Our case from day one has been all of these issues that I've enunciated in my brief and upon oral argument. I respectfully disagree with counsel's depiction of this property as just trash. There were 6 vehicles. One of them, again, was an RV, a large RV that was running. Now, counsel states, and I know he misstated, I don't know if it was intentional or not. One vehicle was reclaimed by my client. That was his father's Cadillac. All the other vehicles remain in storage or who knows where they are. So that statement is incorrect. There are privileges to go on the property if the ordinance is reasonable and constitutional and valid. We're arguing from day one, this is all void. Now, counsel argues that
Counsel, weren't some of the incursions appropriate, the ones that he received notice of?
prior to the ones that we argue about, yes.
Right.
That is correct.
Okay.
Judge, if
all I
you,
needed to know.
okay. Prior to, I would say anything other than reliance upon the habitual violator order. And we're alleging that 9 of those occurred. If you would tell me when I have a minute left, I'd appreciate it.
Yes.
Now, counsel makes a big deal about the hearing itself and the order itself, and argues that since we received notice a year later, we acknowledge that's all they had to do. Well, ironically enough, that argument was made by the city in Seaton's v. City of Atchison. Atchison itself was involved in a similar argument in 1989, and the court ruled when it comes to 1983 claims based upon constitutional violations, the appeal of an administrative procedure is irrelevant. That doesn't control. So even if we could have and failed to do it, that doesn't control the plaintiff's right to bring a 1983 action. That administrative remedy does not need to be exhausted. We argue that property was of significant value. It was taken in a manner that just is really contrary to the most fundamental concepts of due process. Now, counsel seems to argue that, well, a speeding ticket, habitual violator, and all that is different, because simply because the local cop knows that Joe Blow has been speeding all his adult life, he can't stop him, but that's a different factor, he argues. Well, I would suggest that also includes administrative procedures when it comes to driver's license. The case law and the law in the state of Kansas is when there are habitual violators in driving, the consequences get quite harsh, proportionally to the number of violations. The first time, you can be in trouble. The second time, you get in real trouble. The third and fourth time, you lose your driving privileges. Last thing I would like to point out, judges, is that the city's ordinance actually provides for an emergency abatement procedure. So if they were to argue that this was an emergency abatement, they would have to follow their own ordinance that says the code enforcement shall exercise due diligence, attempting to contact the owner, occupant, or property under control of the agent, and seek immediate action to abate the emergency. If such attempt is unsuccessful, the court enforcement officer may act to correct or abate the emergency. There's nothing on the record suggesting this was an emergency, and I would suggest that is in compliance with the enabling legislation. But to argue that the habitual violator ordinance does not violate the enabling legislation is irrational, illogical, and I really think disingenuous. It's clear the enabling legislation says on each and every event, you must do this.
1 minute, Counsel.
Thank you. As I stated in my reply brief, counsel's argument is that we have some type of authority here under home rule, yet the applicable case states without qualification, you don't have home rule authority. Barnes, even though it involved a county issue, referenced the city enabling legislation and said, this takes care of the issue statewide for all cities. You have no home rule authority. There's nothing in the record that even suggests there's a home rule ordinance. In addition, counsel states about all these other previous violations, there's nothing in the record that indicates that the hearing officer even considered those when he issued the order. His deposition, which is part of the record, shows he looked at the order, looked at the file, and really didn't recall much else. Those arguments are without merit. I ask that this court find as a matter of law that these actions are void, illegal, and it should be remanded for the issue of damages. The issue of damages is what at stake, which includes attorney fees under 1983 and 1988. And I want to again emphasize, exhaustion of state administrative remedies in the form of an appeal to the district court is not a condition precedent as established by case law involving the same city established over 10 or 15 years ago. Be happy to answer any questions.
Thank you, Counsel.
Thank you.
Take the matter under advisement. Our last case for the morning, case number 114158, Terrence Kelly versus State of Kansas. Parties state their appearances, please.
May it please court, Your Honor, Richard Klein on behalf of the appellant Terrence Kelly.
Mr. Klein, do you desire any rebuttal time?
3 minutes, please, Your Honor.
3 minutes, okay. You may proceed.
Thank you, Your Honor. This is an appeal of an ineffective assistance of counsel claim that was denied at the district court. The facts behind the case are generally not in dispute. In 1994, Mr. Kelly entered a liquor store. He had a 12-gauge shotgun, and he shot the store owner and clerk in the chest, killing him. He was initially charged with first-degree premeditated murder, an alternative of felony murder, and also charged with aggravated robbery. He worked out a plea agreement, and in that plea agreement, he ended up pleading to felony murder and aggravated robbery, was given a life sentence with a hard 15 for the felony murder and 172 months for the aggravated robbery, amounting to approximately 29 years in prison as a sentence.
You say 72 months or 172?
172 months, Your Honor.
All right, go ahead.
And those are run consecutive, giving him,
Yeah, basically 15 plus 172 years.
yes, Your Honor. In 2007, Mr. Kelly filed a motion to withdraw his plea. The district court in that case construed that as a 1507 claim, summarily dismissed it. Mr. Kelly appealed that. It was sent, the Court of Appeals found that it was not a 1507, sent it back to the district court, who then found that he could not withdraw his plea, that he didn't establish manifest injustice in the case to withdraw his plea. And Mr. Kelly subsequently, that took about 7 years to complete. The mandate came down in the summer of 2014, and Mr. Kelly then filed this ineffective assistance of counsel claim pursuant to 60-1507. That was denied by the district court without hearing. He appealed it, and we're here today. The real issue here is manifest injustice. We acknowledge that it's outside the 1 year time frame that would have run starting in 2004 in this case, based on the current version or the recent version of the statute at that time. He did not file that within 1 year of 2004, and thus we have to establish manifest injustice. And that's the issue before the court.
To show manifest injustice, do you have to allege a claim of actual innocence?
I don't believe so, Your Honor. I think Vontress establishes that a non-exhaustive list of factors, timeliness, the substance of the claim, and then whether a claim of innocence or not guilty is, whether that's claimed.
There's no doubt about it. There's no doubt about guilt in this case.
Mr. Kelly has not in any petition claimed innocence.
He's accepted responsibility.
I guess we could say that. I think, Your Honor.
But in essence, he's making a claim for ineffective assistance of counsel at the time of the plea in 1995.
Yes, Your Honor.
And explain to me how counsel, when they were able to negotiate a lesser sentence for him as the trigger guy, the trigger person, than his two other co-defendants, because of the two other co-defendants went to trial first and received greater sentences, how did he receive ineffective assistance of counsel?
I think your question's asking me to compare apples and oranges. Mr. Kelly's case is not determinative on the other gentleman who involved.
Oh, I know it's not, but it's comparable because they were all joint and severally liable for the acts of Mr. Kelly while the other two gentlemen sat in the car.
But the real issue is whether the issue goes to Strickland. I mean, Strickland lays it out. Were his two attorneys' actions objectively reasonable? And would he have pled if their actions had been objectively reasonable? And our argument is they were absolutely not objectively reasonable.
So tell me why they were not.
His claim is that his attorneys told him that he would get 132 months, he told them that he would get 13 years, he would do 10 years based on good time, and that what he needed to do during the plea hearing was sit there and be quiet, don't ask the judge any questions, say yes to everything, and say you understand it, and then you'll get that deal. That's obviously not the deal he got. 15-year-old kid, 8th grade education, some experience in criminal cases.
Wasn't a novice
but
before the court.
was not a novice, but his claim is that his attorney said that. Now, that's about as egregious as it gets. I'm sure we could come up with some hypotheticals that are worse, but it's about as bad as it gets for a 15-year-old kid with an 8th grade education. If his attorneys told him that.
Wasn't the discussion between the court and your client at the time of his plea rather long and lengthy?
Sure, it was, Your Honor, but if his attorneys told him that, that's what you'd expect. You'd expect him to sit there and agree with the court, yes, I understand, that makes perfect sense, Your Honor, thank you, Your Honor, excellent work, Your Honor. That's what his attorneys told him to do.
What were the answers that he would have given but for the advice of his counsel that contradict what he actually told the court?
What his claim is, implicit in his petitions, is that he would not have pled guilty. He would not have pled guilty if he didn't think he wasn't getting that exact deal.
That he
And-
he would have gone to trial.
Yes, Your
and
Honor.
faced the prospect of first-degree murder as opposed to the sentence that he got.
Implicit in his petition, yes, Your Honor. And what the district court and the state is asking you to do in this case is to assume that this did not happen. And I understand that my final point is this: when we talk about substantial issues in 1507 claims, not dispositive in this case because it wasn't filed within the year time period. If it had been filed within the year time period, there's almost no doubt that the facts of this case would require the district court to have an evidentiary hearing.
So wouldn't your client's allegation about what his lawyers told him to say or not say, wouldn't that affect the validity of every plea that's taken in every case? Because the discussion between counsel and their client is not recorded, whereas the plea is recorded.
The short answer is potentially. With this case, map out the exact thing that thousands of other inmates should probably say in a petition, I guess. I mean, if that's the question, Your Honor,
Well,
yes. He's claiming something that is absolutely egregious.
But when I first started practicing law, I could go before a district court judge, and we would do a plea in 5 minutes. When I left the bench, with all the questions that's required of the district court now, because it's his or her responsibility to make sure the defendant's making a knowing plea, it takes 30 or 45 minutes. And all of that discussion is based upon the answers that the defendant does or does not give during that process. Right?
Yes, Your Honor. The time frame, it takes a lot longer now to do a plea than it did.
Well, it depends on the judge.
Sure.
But still, it's substantially longer today than it was
Yes.
30 years ago. But you're attacking the fundamental issue of the discussions. Your client's claiming his lawyers lied to him.
Not necessarily lied to him, but
Or misled
told him to do something that he shouldn't have done, and told him to do something they should not have told him to do, is the real issue.
And so what you're asking for is a hearing.
Yes, Your Honor.
And, you know, you want to bring the lawyers in, and you bring the defendant in, the defendant says they did this, and the lawyers may say, no, we didn't do anything like that, and then it's up to the judge to determine whether there's a basis for either granting it or taking some other kind of action.
Yes, Your Honor. And the alternative, and I think that's probably the really reasonable thing that I'm asking for.
And if at that
Is it-
hearing, the court hears the testimony of your client saying, rather than take this favorable deal in light of what happened to my co-defendants who were less culpable than I, since I'm the one who pulled the trigger, I still wanted to go to trial. And at the end of that, having heard that testimony, the judge says, I simply don't believe you. And on the issue of credibility, I decide that your claim has no merit. That really ends it, doesn't it?
That's the district court's prerogative. Yes, Your Honor.
That's
And
not a
if-
viable, appealable issue at that point, is it?
Would not be. I don't believe so. And if this had been filed within the time frame, I think the facts of this case, because and I think the case law supports that if there's a difference, conversations that were had between a client and an attorney create substantial issues of fact. I think that the court would have to have that kind of hearing. And again, not dispositive here, but illustrative in what we're asking for.
And one of your claims is that your client was in some extra segregation, I guess it was, and had no access to counsel to bring a 1507 action. Are you saying that in his status, he could not seek a lawyer to help him in this situation?
Judge, I think it's pretty typical for a juvenile sent to prison to be put in administrative segregation immediately.
Okay.
He was 15 years old when he went to prison, and what typically happens is, and I would suggest this is almost common knowledge, is he'll be in administrative segregation. He'll continue to do small things that keep him in administrative segregation. In this case, according to him, he was in administrative segregation until 2007, which is his first opportunity to.
Was that to basically keep him away from the adult population?
It
in
is, Your
prison?
Honor.
It's not, isn't designed to keep him away from access to a lawyer, is it?
I think it ends up having the same effect.
Well,
'Cause
are
he's
you
not-
saying that if he's just being segregated because he's a juvenile, we want to keep him away from adult prisoners, that if he says, I'm here under a sentence, under a plea that I should never have made, that I was misled into, I need to talk to a lawyer about that, he has no access to a lawyer?
I think it has the same effect. He doesn't have the ability. He's 15 years old. He's a kid. He doesn't have the ability to figure out how to even ask for an attorney. I don't think at that point would be. I think that's a fair argument.
Well, isn't there a real argument that this issue is res judicata because the Supreme Court addressed it in its case, 298 Kansas at 970 or thereabouts? In finding where the Supreme Court said that it rejected his arguments, finding it was clear Kelly understood what he was pleading to, and it was also clear Kelly received a significantly lower sentence as a result of his attorney's negotiations than he would have most likely received at trial. Hadn't that already been litigated in his first appeal through the Supreme Court?
The issue of his attorneys telling him to sit at the plea hearing, be quiet, don't say anything, to make sure you get this exact deal was not litigated previously.
So you're parsing the issue on that point. He got the benefit of a very beneficial plea through the efforts of his attorneys, but he's claiming he was entitled to even a better deal. Or he was told he was going to get a better deal.
His claim is that he's entitled to a trial at this point. I think he's not getting a better deal. I think we all know
The
that.
trial on the 1507 or the?
No, murder.
On the murder, if the 15,
He
I mean, I
wants,
think,
he wants a trial on
think-
that.
I think implicit in his petition, that's what he's asking for.
Have you talked to your client about that?
I've talked to him about the,
You know, we
pros
have
and
instances
cons
where counsel have
of-
advocated positions that in the long run, we're going to do more damage to their client than otherwise. And we've had family members reach over the rail and tug at the lawyer's sleeve saying, wait a minute, I don't think this is what our son wants.
he wants a hearing on the
A
1507.
hearing or a trial?
A hearing on the 1507.
Okay,
Which
that's-
would lead
That's
to a
the-
trial.
Which could potentially, yes, Your Honor.
Okay.
Be careful what you ask for.
I think your time's up, counsel. I think we understand your point.
Yes, thank you.
And I just say that in jest.
No, I understand, Your Honor, completely.
Thank you. Nice argument.
May it please the court, the state appears by Stephen Obermeyer.
Mr. Obermeyer, this issue has come up in my mind many, many, many times, and it may have in yours. Let us assume, as I think we must, when things are in this status, that our defendant is telling the absolute truth, that he was told he would get a much better deal than this if he just kept his mouth shut, didn't say anything, agreed with everything that the judge or his lawyer said. And then, when things were all over with, he found out that he didn't get what he thought he was going to get. Now, wouldn't that at least allow him to have a hearing on his 1507? Not necessarily that it's going to succeed, because of the Supreme Court's previous ruling, one would have a great deal of doubt that it would succeed. But isn't he at least allowed his one shot at a 1507?
I think the answer to that, Judge Perrin, would be yes, if he timely filed his petition. And with everything that counsel had said, that my attorneys railroaded me, they lied to me, they violated their ethical duties as attorneys, I should get a hearing. And he would have known that back in April of 1995, because that's when he was sentenced. Now, how long
Well,
can
he had
he?
been told, though, to keep his mouth shut and not to rock the boat.
Okay.
And assuming that that's true.
And so he knew that he was done wrong back in April of 1995. So if you're really mad about something like that, when do you want to go out and do something about it? 1996, 1997? He turned 18 in 1998, so could he have filed it then? 1999, 2000? He waited until 2007 before he filed a motion to withdraw his plea. And the court looked at the transcript, and thank heavens that, the court reporter took a good record of that, and he had two attorneys, an attorney for when he was in juvenile court and the adult court attorney, discuss with Judge Steve Tatum at the time everything they went over with him. And in the context of this is within a couple of months perhaps after the co-defendants, the wheelman that drove to the liquor store, and the backseat passenger that said, let's park here, this is a good liquor store, it's pretty dark here, let's rob this one. After they went to jury trial for aiding and abetting and were found guilty and got a bigger sentence. And so the defense attorneys were looking at the possibility of a hard 40 sentence, so 40 years automatically before you are eligible for parole on the murder, plus the aggravated robbery of 172 months. So I think if you look at it in the context of that lens, that he should have done something at least in 2007, but certainly before 2015. And we've had this manifest injustice argument before, because the Supreme Court considered it in deciding whether or not there should be a hearing on setting aside the plea. And just for the benefit of the audience, Manifest injustice is something that's shocking to the conscience, that's unconscionable. And the Kansas Supreme Court said that this was not shocking to the conscience because trying to set aside a plea is not something that's subject to temporal manipulation. You just can't sit on your rights and wait for the state to have the property destroyed and let the witnesses get 20 years older and then have the defense attorneys come back and say, Mr. Earhart and Cornwell, back in 1994, what did you tell the defendant? How did you handle that case? And the law used to be that way. I mean, this case is about, can a criminal case that ends with a guilty plea, when can that be considered concluded? And it used to be, you could come back and complain about your attorney at any time. And in about 2004, the legislature amended the statute to say 1 year unless there is manifest injustice. And so that's where we are. He should have filed it in 2005. We're 10 years out of that. And the district court judge considered the Von Truss case and said there's 3 factors that we look at. Just for the court's information, there's one of the factors in Von Truss says that you look at the merits of the claim. For the court's benefit, House Bill 2502 may be signed in the cleanup session that's going to get rid of that particular prong, and we're
Try to predict legislative action.
well, I'm not, but I'm just as part of the back and forth that Judge McEnany was talking about with the courts and the legislature, that in an effort to address that prong of Von Truss, there has to be an explanation why you waited 20 years or why you're out of time. But
Well, can't we ask him that?
yes, I think you could.
Well, you'd have to have a hearing to do that, though, wouldn't you?
Well, he put in his motion why he didn't file it in time, that he was in administrative segregation. And I find it hard to believe that somebody born in 1980 would still be in administrative segregation in 2007 because he was a juvenile when he went into the system.
Well, he's
There's
claiming that, isn't he?
I don't know why he.
Claiming that he was in segregation.
Well, we could look up on Casper and see why he got in administrative segregation. I don't think it was because,
I think it was the first 7 years.
okay, but he was an adult.
Until he was 21, basically.
Okay, he would have been an adult in 2001. He would have been 21 in 2001. So I don't think they're still treating him like a juvenile in 2007, and the record doesn't set out that that's why. So Judge Welch looked at the 3 non-exclusive factors set out in the Von Truss case. The third one, whether the prisoner sets forth a colorable claim of innocence. And he clearly admitted that he did not intend to shoot the man. It was a robbery. At sentencing, his counsel said he's not trying to hide that. He wants everybody to know that he was sorry. And that was in response to the defendant's statement in the pre-sentence report that I really didn't think nothing about it, but the dude shouldn't have made it so hard on himself. And this particular dude, just by way of background, his mother died in that same liquor store about 5 years before by a different robber. It's located about a mile south of the courthouse. And this happened during Old Settlers days where 14-year-old Terrence Kelly, T-Money, wearing a Thug Life hat, came up from Parsons with his sawed-off shotgun to Old Settlers, and they were looking for a liquor store, and they were mad because the clerk would not sell them liquor because they were obviously not under 21.
Does
So,
that really have anything to do with this case?
well, I'm addressing the fact that
The
there's
issue that has been raised?
there's no actual innocence. So that's one thing that we have that factor. The second factor, persuasive reasons that prevented him from filing it within the 1 year. And Judge Welch said he filed a lengthy memorandum of law in support of his motion to withdraw his plea in 2007. So obviously he's out of segregation or able to write lengthy motions in 2007, and he clearly had access to legal resources within the prison as of that time. And he's had 2 prior appeals that went to the Supreme Court. I would assume that attorneys talk with their clients, and if there was an issue, hey, maybe we can file a 1507 or something. But to say, I've just been shielded from counsel for all this time, I don't think it's pled in the motion, and it just doesn't make sense. At any rate, when you make your claims, you should do it all in one writing, one claim. The court doesn't write opinions and say, well, I want to write another opinion later explaining this. You have to do it at the time. And he should have raised all of his claims at the time, especially when they're so egregious as he claims they are. Why not put it in that first motion? But he didn't. So we have the other prong, not persuasive reasons or circumstances that prevented him from filing. The second prong, the one that may be subject to legislative change, whether his claim raises substantial issues of law or fact deserving the district court's consideration. Judge Welch went through all those factors, looked at the extensive plea of the colloquy, and even though this was in 1994, that was a very lengthy plea hearing that they had at that time. And by entering this plea, Kelly was avoiding the chance that he'd serve the rest of his life in prison. And so I think the court could look at the context of this case as far as when the plea arose, and that it was after the co-defendant's cases to say that, to make that ruling. The Kelly II court, the Supreme Court said, we hold that Kelly fails to demonstrate the manifest injustice required by the 223210 to withdraw his guilty plea. Is there a different kind of manifest injustice in a 1507 action? I don't think there is. I think they cite the same cases that we're talking about, obviously unfair or shocking to the conscience. And so his claim was time barred. He was way outside of the statute of limitations, and the court did not find the manifest injustice to allow consideration of that. And for those reasons, I would ask the court to look at Judge Welch's order, which is in the appendix to the blue brief. And this is the one chance where attorneys can kind of copy, students can't. But anyway, I'm just borrowing from her work because she sets out reasons why she...
By reference, counsel.
Yes. All right, by reference. And she said this claim could have been raised in 2007. It was not, nor does he point to unusual events or intervening changes in the law which would have prevented him from raising this issue when he brought his previous claim within the motion to withdraw plea in 2007. So for those reasons, I would ask this court to affirm the order written by
But I
the
would
district
say,
court.
counsel, that we're seeing more and more cases of people who've been in prison for 20 years, 30 years, 33 years. Turns out they didn't do it, you know? And I'm not saying that, you know, every time somebody claims something, well, obviously that's true, we'll grant you a new trial or something, even though everybody's dead now. But I'm not sure you can make a strong argument saying that, well, you know, if 1 year has passed or 7 years has passed, there's no possibility that the person wasn't convicted. And I'm saying we know that isn't true. And it's just a little difficult to say that you can't even have a hearing on it because, you know, too much time has passed. Now, it may turn out that that is the appropriate decision to reach after you've had an opportunity to hear all the facts, but I don't know, I think you might have more problems selling that in light of the history that we have of people being convicted when they didn't actually do it.
Right. And in response to that, Judge Perrin, I would just say we have a post-conviction DNA testing statute. It's KSA 212512, and that would qualify if, and you don't have to have a claim of actual innocence made. You can just have this new DNA testing.
Well, he's not claiming that.
Correct. And I guess even after this proposed legislation, a colorable claim of actual innocence would still be a factor. And that's not an issue here. He's not claiming I'm now saying I didn't do it. And so I think that remains in play as one of the factors the court can answer. Because I have police officers in homicide cases calling me after the appeal's over saying, can we get rid of the property now? The gun, the bloody clothes? And I had to say, no, even though this was a 1994 case, who knows what's going to happen? And so all this property is somewhere in Olathe Police Department's property room. And at some point, there ought to be finality and closure to it, and I hope this is it. Thank you.
Thank you, counsel. Rebuttal? You have 3 minutes, counsel.
Very briefly, Your Honor, I'll just highlight, Vontress is clear that the factors should be considered under the totality of the circumstances. They need not be given equal weight, and no single factor is dispositive. So I don't think that he has to come forward with a claim of innocence. And I'll say once again, you would have to assume that what he is saying is not true. I don't think the record, looking at the record, we can assume that what Mr. Kelly is saying is not true. And if what he says is true, it's fairly egregious. It would definitely meet the first prong of Strickland. It is a manifest injustice if this is what happened to this 15-year-old kid with an 8th grade education. And I would ask again that he be given an evidentiary hearing to get this cleared up with the district court. Thank you, Your Honor.
Thank you very much. We'll take that under advisement. That concludes our morning docket. We're in recess until 1:30. We have, as I said earlier, 2 cases to deal with this afternoon. We are in recess.
All rise.